Debt verdict, DV023. Title, he was sued for a debt he already paid. Formula, revenge, duration 10 min. Tag, zombie debt, debt buyer fraud, lack of documentation, consumer defense, FDCPA. A debt collector sued a man for $10,400 on an old credit card balance. There was just one problem. The collector couldn't prove they owned the debt. They couldn't produce the original credit agreement. They couldn't show a single statement or payment record linking the borrower to the account. They had purchased what the industry calls a zombie debt, a debt obligation bought for pennies, resurrected with a lawsuit, and weaponized against a man who may not have owed a dime. He didn't roll over. He hired a lawyer. And what happened next cost the collector far more than the $10,400 they were trying to collect. Every year, billions of dollars in consumer debt are sold by original creditors, banks, credit card companies, hospitals, utilities, to debt buyers. The debts are sold in bulk, often in portfolios containing thousands or tens of thousands of accounts. The price? Pennies on the dollar. According to a federal study on the debt buying industry, one of the most comprehensive ever conducted, the average price paid for charged-off credit card debt was 4 cents per dollar of face value. A $10,000 debt sells for $400. A portfolio of 10,000 accounts with a total face value of $50 million might change hands for $2 million. At those prices, the buyer doesn't need to collect on every account. They just need to collect on enough to turn a profit. But here's the critical detail that federal investigators found. When these debts are sold, the documentation that comes with them is often incomplete, outdated, or non-existent. Original creditors sold debts with no documentation at all in a significant percentage of cases. When documentation was provided, it was frequently limited to a spreadsheet, a data file containing the debtor's name, an account number, and a balance. No signed credit agreement, no monthly statements, no payment history, no proof that the person named actually owes the amount claimed. And debts don't just sell once. A bank sells to buyer A sells to buyer B sells to buyer C. Each sale strips another layer of documentation. By the third or fourth buyer, the paper trail is severed completely. The industry calls these zombie debts. Debt accounts brought back to life by collectors who rely on one assumption: the person being sued will not fight back. According to court documents, a debt purchasing company filed suit against a borrower, referred to anonymously in FDCPA case studies, for $10,400 on a credit card. The complaint was bare bones: a credit card issuer, an account number, a balance, payment demanded in full, plus interest, plus attorney's fees. What the complaint did not include was any documentary evidence. No copy of the original credit card agreement bearing the borrower's signature. No account statements showing charges and payments. No assignment documents proving the collector had purchased the specific debt from the original creditor. No chain of title documentation showing how the debt had moved from seller to buyer to buyer. In thousands of similar cases across the country, this would have been enough. The debt collector would file the lawsuit. The debtor, intimidated, confused, or simply unaware of their right to respond, would fail to appear in court. The collector would obtain a default judgment, and with that judgment, they could garnish wages, levy bank accounts, and place liens on property. According to a legal aid study, debt buyers obtain default judgments in roughly 95% of cases filed in New York City. The system was designed for volume, not adjudication. This borrower was not going to be part of that 95%. The borrower contacted a consumer rights attorney specializing in FDCPA litigation. The attorney saw exactly what he expected: a lawsuit built on nothing. The defense was straightforward. The collector bore the burden of proof. They needed to prove 3 things: the debt existed, the borrower owed it, and the collector had purchased it through a valid chain of ownership. The attorney filed an answer denying every allegation, then sent discovery requests. Produce the original signed agreement. Produce monthly statements. Produce every purchase and assignment agreement in the chain of title. The collector produced one document, a spreadsheet printout with a name, an account number, and a balance. No signature, no statements, no chain of title. The attorney moved for summary judgment. The court agreed. Case dismissed. But the borrower wasn't done. His attorney filed a counterclaim under the FDCPA. Section 1692E prohibits false, deceptive, or misleading representation. Section 1692F prohibits unfair or unconscionable means of collection. Filing a lawsuit without documentation, the attorney argued, was both. The collector was now on the defensive. The lawsuit they'd filed as a profit-generating exercise had become a liability. Statutory damages, actual damages for stress, and under the FDCPA's fee-shifting provision, the borrower's attorney's fees. The case settled. The collector paid the borrower. According to court records, FDCPA settlements in cases involving baseless lawsuits typically range from $5,000 to $25,000 or more. The collector had purchased the debt for pennies. They ended up paying dollars to the person they sued. This case was a symptom of a systemic problem. According to federal reports on the structure and practices of the debt-buying industry, debt buyers filed lawsuits based on data files alone. They rarely possessed original documents. They sued on debts past the statute of limitations. They sued wrong people for wrong amounts. Federal regulators took action. Two of the largest debt purchasing companies in the country agreed to consent orders totaling over $90 million. Stop collecting undocumented debts. Stop filing unsupported lawsuits. Refund improperly collected consumers. Several states now require debt buyers to attach specific documentation to collection lawsuits: original agreements, complete chain of title, last creditor statement. New York, California, and Maryland among them. But enforcement remains uneven. Debt buyers still file hundreds of thousands of lawsuits per year. If you are sued by a debt collector, do not ignore the lawsuit. A default judgment lets them garnish wages and seize bank accounts. Instead, respond. File an answer. Deny any allegation you don't believe is accurate, and demand documentation. Under the FDCPA, you have the right to request debt validation within 30 days of first contact. But even beyond that window, in a lawsuit, the collector bears the burden of proof. Make them prove it. Specifically, demand the original signed credit agreement. Demand monthly statements. Demand the chain of title, every purchase and assignment agreement from the original creditor to the current collector. If the collector can't produce these documents, their case collapses. Many legal aid organizations offer free representation in debt collection defense cases. The National Association of Consumer Advocates maintains a directory of FDCPA attorneys who take cases on contingency, meaning no upfront cost to you. The debt-buying industry thrives on silence and default judgments. The single most powerful thing you can do when sued is show up and make them prove their case. One borrower showed up. The collector couldn't prove a thing, and the person who was supposed to pay became the person who got paid. If you've ever been sued over a debt you didn't owe, or fought a collector and won, drop your story in the comments. Subscribe for more stories of debt and justice. Disclaimer: this video is for educational and informational purposes only and does not constitute legal advice. The events described are based on publicly available court records, federal reports, and consumer advocacy case studies.